$1,200 every minute I'm in jail.
Show that the judges refused.
Sir, don't interrupt me again, okay? Don't interrupt me again. Let's set a motion date for.
Do not consent.
Probation will be a waste of time in this matter, so I will revoke, remand you to serve her sentence, take her into custody.
Please don't do not say anything else, sir.
Sir, I'm exercising my Sixth Amendment right. The Sixth Amendment, the exercise of an amendment right to be converted into, sir.
I'm holding you in contempt of court, sir.
Court, I see no evidence that has the needed personal subject matter jurisdiction. The state is a fictitious plaintiff. The state of isn't here to testify. No injured man or woman is present before this court to provide first-hand knowledge. I am acting as surety for the named principal to contest jurisdiction.
Wait, did he just casually admit he got the job from the dark web? That's the kind of statement that instantly changes the entire tone of a sentencing hearing. At this point, the judge isn't just hearing excuses, he's hearing a pattern.
Versus Ashley Clark, 22 CR 216, Mr. Fallsgraf.
No. Your Honor, this comes before the court today on a probation violation hearing. And it's the intent of the defendant at this time to stipulate. And I do believe there's a agreed sentence, as you would say in this case.
All right. Ms. Clark, you've heard the announcement of your attorney. Is that what you want to do? Admit to the violations?
No, actually, I'm gonna make a motion for my attorney to withdraw. I got this myself.
Oh, okay. What's the reason for that?
I just want to represent myself.
Okay. All right. Well, somebody give her a waiver of attorney form. Okay. It's muted for some reason. All right. Well, I've already gone over these rights with you, so you should understand them. But you have the right to hire your own attorney. If you can't afford to hire an attorney, I've already appointed one. You qualified. You do have the right to represent yourself as well. And that's what you want to do today?
Yes, sir.
All right. If you want to waive your right to an attorney, when we do this, you have to follow the rules of procedure and evidence just as if you're an attorney. You understand that?
Yes, sir.
All right. Does anyone promise you anything or threaten with anything to get you to waive your right to an attorney?
No, sir.
All right. Looks like you've already signed it and sent it in here. Did you understand this form you signed?
Yes, sir.
I'll accept your waiver and allow you to represent yourself. All right. Are you wanting to stipulate to the violations, or do you want a contested hearing?
I'm gonna contest it.
All right. Mr. Hollis here.
Yes, Judge, I can grab him real quick.
Okay. Okay. State has the burden. Any opening statement, Mr. Marcinski?
No, sir, thank you.
All right. Ms. Clark, any opening statement?
No.
All right. State may call this first witness.
Thank you, sir. The state would call Court Service Officer Christopher Hollis. Sir, will you please state your name for the record?
Chris Hollis. I'm a court services officer.
In that job occupation, were you assigned the supervision of a Miss Ashley Clark? That supervision being for an endangering a child underlying 12-month sentence?
That is correct.
On May 18th of this year, 2023, did you test Miss Clark for the presence of drugs?
Yes.
And what was the result of that UA sample from Miss Clark?
It was positive for methamphetamine.
So her UA was positive for methamphetamines, and she also, in response to that positive UA test, signed in a statement of admission of using methamphetamines?
That's correct.
Did you order her to report on June 2nd, 2023?
I did.
And did she appear on that day?
She did not.
Has she appeared or reported to you since that time?
No.
Sometime after May 24th of 2023, were you advised by local authorities of her being arrested for a new crime?
Yes. And I did. I received that. and apparently she has new charges.
To your knowledge or to the notes, did Ms. Clark ever report that negative law enforcement contact with your office?
No, she did not.
That will be my questions for Mr. Hollis at this time, Your Honor. Thank you.
All right, Ms. Clark, do you have any questions for Mr. Hollis?
No.
All right, do you have any further evidence or witnesses, Mr. Marcinski?
Not at this time, Your Honor. I do not.
All right, Ms. Clark, you have time to, now it's your turn to present any evidence if you want to. Do you wish to present any evidence?
Right now, I see no evidence. This has the needed personal subject matter
Argument.
jurisdiction.
If you want to present any evidence, do you want to present any evidence?
No.
No? Okay. Well then, closing argument, Mr. Marcinski?
Your Honor, at this time, the state believes it is shown by a preponderance of the evidence that Ms. Clark is in violation of her probation and conditions of probation imposed by the court therein. The state's going to ask that you find that she is in violation of that probation. The state would point out that this is a misdemeanor probation for endangering a child. Therefore, Ms. Clark is entitled to no graduated sanctions, intermediate sanctions, or other relief set forth by the legislature on felony probations. Due to the litany of violations, the continued drug use, the failure to follow through with her treatment requirements, the state believes that she's shown that she's not amenable to probation and would recommend the court revoke and remand her to serve her underlying sentence.
All right, Ms. Clark, closing argument?
There are no facts to dispute before this court. I see no evidence that has needed.
This is where the case stops being about one attempted fraud and starts revealing the real-world consequences. Notice what the victim is describing: payroll systems, security changes, extra employees, and hours of lost time. Fraud doesn't just target bank accounts, it creates chaos for everyone connected to them.
That has the needed personal subject matter jurisdiction. The state is a fictitious plaintiff. The state of isn't here to testify. No injured man or woman is present before this court to provide first-hand knowledge. I am acting as surety for the named principal to contest jurisdiction. I am aware this is a taxable event and an excise tax is owed, and I want to be in compliance with the IRS code.
Okay. It'll be the order and judgment of this court. Well, first of all, I'll make my findings. The state's shown by preponderance of the evidence that you violated probation in this case using methamphetamine around the 18th, as evidenced by the 18th of May this year, as evidenced by the positive UA in the admission. Also find that you failed to report in violation of probation as alleged. That would be the June 2nd, 2023 date. You failed to successfully complete outpatient treatment at Summer Mental Health as ordered by the court, so I find you violated probation there as well. You also failed to report law enforcement contact within the business day in violation of the orders of probation. You have violated it in a very substantial way. I will go ahead. It appears as if probation will be a waste of time in this matter, so I will revoke and remand you to serve her sentence, take her into custody.
All right. $1,200 every minute I'm in jail.
Yeah, so I am Jamil of the family Lockhart, flesh and blood living man and attorney in fact for Jamil Lockhart and Legis Trust. I'm here by threat, press, and coercion. I'm here making a special appearance. And I'm here to demand that the court prove jurisdiction over me as a live flesh and blood.
You've been here before, correct?
Yeah, I've been here before.
Have you made any kind of filings on your behalf?
Yeah, quite a few.
This is the city of Detroit versus Jamil Amir Lockhart. Appearance for the record, please.
So I am Jamil of the family Lockhart. The motions that I filed and the documents that I have filed have all been trying to ascertain the jurisdiction of this court. And I don't understand the nature and cause of the action against me. And I'm trying to understand under what jurisdiction the court intends to proceed. First of all, is this going to be a civil or a criminal action?
Criminal.
Criminal. Okay. Your Honor, the Constitution grants this court two criminal jurisdictions. One is criminal jurisdiction under the common law, and one is a criminal jurisdiction under admiralty or military tribunal. From Article 1, Section 8, Clause 817 of the Constitution. So in which of these two criminal jurisdictions does the court intend to try?
Where is your motion, sir?
There's a motion filed there. It's a motion to dismiss based on lack of subject matter jurisdiction.
All right, I'm going to deny that motion. I'm going to set a bench trial or jury trial if you choose. Which one would you want to have?
Okay, Your Honor, under what grounds, what facts and findings, conclusions of law are you denying that motion to dismiss? I'm trying to understand the jurisdiction of the court. You have not disclosed it to me. I'm asking you.
To disclose it to you. Check the court rules, sir.
Well, Your Honor, the Sixth Amendment grants me the right to understand the nature and cause of any action brought against me, and it grants you the duty to inform me. So I don't think you would be breaching your oath of office if you were to inform me under which jurisdiction this court intends to proceed. In order for me to intelligently defend myself without an attorney, I need to understand which jurisdiction the court intends to proceed to conduct defense.
We have a very good attorney on the line, Mr. Elwood Terry. If you want to speak to him in a breakout room, I can give you that opportunity. Other than that, I'm going to set a bench trial or a jury trial in the matter.
Okay. Please let the record show that I have attempted to understand or to ask what is.
And here's the detail that judges pay very close attention to: repetition. One bad decision can sometimes earn leniency. Multiple similar allegations across different states, that's when a court starts seeing a lifestyle instead of a mistake.
The jurisdiction of the court is operating under, and it appears that the court is operating under a secret jurisdiction, maybe only known to bar members and licensed attorneys. So let the record show that I am trying to understand jurisdiction and nature of cause against me, and the court has denied me that information.
I'm not denying you the information. The information is public information, sir. The information is outlined in the Michigan court rules. You need to read the Michigan court rules, and you can find out jurisdiction. It'll tell you everything about jurisdiction. That's entirely public information. You can go online and type in the court rules, the whole book. That ascertain to you online.
Sir, the Sixth Amendment grants
I'm
you
not
to
required.
inform me of the nature and cause of any action brought against me. And right now, you're denying that right.
Sir, don't speak over me. You want me to inform you of the nature and cause of the action. You're charged with driving, drive while license not valid or improper. The other charges, no insurance, misdemeanor. The allegation is that you were driving the same 2011 Jaguar in the city of Detroit without the proper registration on that vehicle.
I understand the
maximum cost. Don't interrupt me, sir.
Okay, go ahead. I'm sorry.
Those are the charges. Do you want a bench trial or a jury trial?
Your Honor, I am trying to understand the jurisdiction of this court. As I said, you told me it was a criminal jurisdiction.
If you read the Michigan court rules will tell you and give you jurisdiction. So they have a copy of the Michigan court rules online or at the public library. I'm sure it is not as easily ascertainable, and we're not going to keep going down this road, young man. Do you want a bench trial?
So I cannot. I'm asking you a very specific question, and it is this a criminal jurisdiction under common law, or is it a criminal jurisdiction under military tribunal?
Listen, it's let's move on to the next person.
Sir, please answer that.
It
can only be one or the other.
You'll leave me no choice but to hold you in contempt. I'm asking you a specific question, you're
Your Honor, I do
disregarding.
not wish to
And
be
I'm
held in
gonna-
contempt. I am trying to exercise my Sixth Amendment right. I can show you Constitution is exercise of a constitutional right cannot be converted into a crime, sir.
Sir, the way you speak to the court is via motion, okay? If you have a motion that I've already denied one of your motions, if you have another motion, present it
Under
to the
what
court.
basis? Under
I'll
what
give you the
grounds have you
opportunity.
denied my motions?
It's not my job to explain to you all of the court rules, sir.
So there's
You're
only
gonna
two
represent
jurisdictions
yourself.
in this court
You're
can
gonna be
operate
treated
under.
just like any other, you're gonna be treated just like any other lawyer that comes in this courtroom. So you have to know the rules.
Yeah, so I'm not trying to seek legal advice or ask you what the rules are.
You
I'm
need
asking you
to.
I'm asking you a very specific question. There can only be two jurisdictions under criminal law. And is it under common law or is it admiralty law?
On the record for Mr. Jamil Lockhart.
Yes.
All right, this is the last time I'm gonna say this. I'm not gonna continue to go back and forth with you regarding court rules and all of those positions that you have. If you put it in a motion, we'll set a motion hearing date.
If you are setting a motion hearing date, you are doing so without my understanding of the nature and cause of the action.
This is the moment that makes cases like this complicated. On one hand, homelessness and addiction are real struggles. On the other hand, the court still has to decide whether those struggles explain the conduct or simply provide context for it. What do you think?
Against me,
Listen,
and
I'm not getting
I cannot
all
move
that.
forward until I have these questions answered. These are basic questions that you are obligated under the Sixth
I'm
Amendment.
not obligated to answer any of that stuff. I told you, I gave you the answer to that stuff by looking in the court rules. You're obligated to know the rules.
Sir, what you mentioned is statutory law. And if we are proceeding under some kind of statutory law, I motion that we dismiss for lack of a sworn complaint or anything signed by injured party. And in fact, where is the injured party? Is the officer present, and who is the injured party in this case?
The officer is not required to be present today. It is a pretrial date. I'll hold that dismissal motion in abeyance until the date of trial. If the date of trial, if there's no signed complaint on the date of trial, then we will dismiss by no signed complaint. So I'll give the city an opportunity to come up with a signed complaint. If
I'm
there's
sorry,
no
is the
signed
city the injured party here?
Yeah, you're here.
Okay, well, sir, I move that we either dismiss this case or move this case to federal court. If the city is the plaintiff or injured party, they cannot also be the judge and prosecutor.
File a motion on that, sir. If you're saying that I do have a signed complaint one.
Well, that brings me back to my original question. Is this a statutory proceeding? Because if there is, there would have to be an international contract or agreement. And I would implore the prosecution to put that agreement on the record and explain how I am party to it.
Young man, you gotta go do your homework, okay? And it appears that you're taking this position and you're adamant about this position, and you're free to do that. Now, whether you're gonna win at this position, that's gonna be up to what you say in your brief, and how it relates to the law, and we'll make a decision on that stuff, okay? But at this point, you need to educate yourself, because you seem like a very articulate, educated young man. You need to educate yourself on court rules and procedure. Until you get it correct, we can't talk, because we have to be speaking the same language, okay?
I mean, that's the main thing I'm trying to understand here, sir. Is this a
So
common law
I'm
criminal
giving
procedure
you
or
I'm giving you some direction on.
Well, sir, I don't know which rules. If you could tell me where I could find the rules for
I
criminal
told you, go to Michigan court rules. They got Michigan court rules.
They have rules for criminal procedure under statutory law.
Yes, very much so.
Could you please direct me to that?
I've already directed you to it. Michigan court rules. There's a book that's over 1,000 pages, and it'll answer, well, close to 1,000 pages. It has those questions outlined in there. You're expected to know
Are
that.
those Michigan court rules? Is that statutory law?
I'm not going to keep going back and forth with this. Whatever motions that you have, that's how you speak to the court, through motions. And whatever motions that you have, I will review it. I read all the motions that come across. I check all the law myself. And if you have some law, I would suggest that law that you're saying that we don't.
Your Honor, there is no international contract. I mean, we've asked the prosecutor to produce an international contract that would bind me to the statutory proceeding. And I'm not aware of any contract. In the absence of such contract, I motion that we dismiss this case. And for the record,
There it is, the moment everything changes. When a judge openly says they no longer find a defendant credible, the sentencing outlook usually becomes much more difficult. Credibility is currency in court, and right now the judge is saying the account is empty.
So in order to, you can move to the circuit court, and you can appeal my decision as it relates to that. But we're not going to keep on going back and forth.
I think we should move this case to federal court. As I stated, if the city is the injured party,
file a motion so I can, on your removal motion, file a motion.
I do not wish to continue or delay this any further. There's been no evidence presented to substantiate any kind of jurisdiction in this case. This is our second time. I've asked for this the first time, and there's been no evidence of any jurisdiction. And I don't understand why, you're insisting on, moving to another court date, and we have not addressed this very basic and fundamental issue of jurisdiction. If it cannot be proven and proven on the record, then this case must be dismissed. Well, I mean, I don't understand why we are delaying this any further.
We don't have to delay it any further. I can put a warrant out for your arrest, and you don't have to show up. I mean, you'll have to deal with that then. But at some point, you're gonna have to deal.
Under what grounds? Under what basis are you putting a warrant out for my arrest? And you
I didn't say I was gonna put a warrant. I said if you're telling the court that you're not gonna come back to any court dates, then that's up to you. All I can do, what I'm
saying, sir, is I don't wish to delay this any further. There has been no proof of jurisdiction. There is no live injured party. I mean, there's a claim that the city of Detroit is an injured party, but I'm not aware of any international agreements or contracts that I've entered into with the city of Detroit. And the prosecutor can't provide that. And it seems like there's a bias going on here because flat on its face, the prosecutor hasn't even spoken on this issue. And you just insist that we move to another court date. And I don't understand. I mean, your oath of office is to uphold the Constitution. And what I'm asking is
what you're saying in essence is that I don't have any authority.
I'm asking you to prove your authority.
I'm
asking you to prove your authority. I'm trying to understand where your authority is coming from. And you're failing.
Read the Michigan court rules, read your statutes, read the Constitution over again, and you'll find that.
As I said before, I'm not asking you for legal advice.
And the Michigan Constitution.
You have, if you have a legitimate jurisdiction, I'm asking you, is it a criminal jurisdiction under statutory law, or is it under the common law? And you will not answer that question. Your Honor, we cannot proceed until I understand the nature and cause of the action against me. I'm gonna say this one last time to you, sir. Go, and if you want to speak to the court, if you have any objection to the court and these dates, and if you don't feel that these dates are lawful, and if you whatever your claim is that you're stating, you speak to the court through motions,
I want that and those motions that you're entertaining on the record right now. I've dismissed some of them already. I want you to file those motions with the court.
Under no basis
So
or
that
ground.
the court can read your motion and make a ruling and give the city attorney an opportunity to respond. If you do it the proper way, you might learn something. But I don't think that the way that you're going, that you're even if they show you documentation like it is in black and white, you're not going to believe that anyway. That's the perception that I'm getting from you. So I'm going to set these dates. It's going to be up to you whether you want to come to these court hearings or not. And if you don't come to the court hearings, the only recourse I have.
Watch how the focus shifts from the crime itself to public safety and deterrence. The judge isn't just asking, what happened? He's asking, what is most likely to happen next? And that question often determines whether someone walks out on probation or leaves in handcuffs.